Well, it's a little after 1:30, and if we're going to keep enough time in our proceedings to have some questions, I think we should probably get started. Personally, I think that the question and answer sessions are some of the most interesting, so let's try and take a break, maybe sometime in the middle of this afternoon to get some more questions. Where we're going to pick up this afternoon is with the defendant's perspective on class proceedings, and we have two speakers. Mr. Ian Binnie, QC, from McCarthy Tetro, and we have Leah Price, who's the acting director of Crown Civil, Ministry of the Attorney General, a former colleague of mine. And Mr. Binnie is going to lead off, and just by way of background, as I mentioned, Mr. Binnie is a partner with McCarthy Tetro. He has his law degree from University of Cambridge in 1963, a master's in 88 from the University of Toronto. He's called to the bar of England, of Ontario, and of the Yukon Territories. He was appointed Queen's Counsel in 1979 and has a long and very prestigious list of clients, including he's the legal advisor to the Treasury Government of Tanzania. And I'll leave you to work through the balance of his considerable areas of expertise that are set out in the biographical note that's in the material. As I mentioned at the outset this morning, Mr. Binnie's paper is a particularly good one, and it gave me more than a couple of chuckles last night when I was reading it. So here's Mr. Ian Binnie to tell us about the defendant's perspective.
Thank you very much, Michael. What I wanted to do is to start with a moment or two dealing with the PR exercise that's going on with respect to this bill, because the Attorney General's Department is having it that all parts of the community are clamoring for the introduction of the class action proceeding. And I can see why plaintiffs are enthusiastic and why uneconomic cases and uneconomic plaintiffs banding together can bring forth litigation where none would exist before. I can certainly see why lawyers are interested for the creation of new galaxies of clients and special arrangements for contingency fees and a law society fund to pay disbursements that otherwise might fall on the lawyer's head. The opportunity for the rather glamorous class actions that we read about south of the border and to a lesser extent in the province of Quebec. I can see why the government is keen on it because it's a very cheap addition to the regulatory framework. In effect, instead of the government having, for example, to sponsor the CRTC to deal with Bell Canada's charging practices in proceedings the expense of which largely falls on the shoulders of the government. One now allows the subscribers to band together and chase Bell through the courts at no cost to the government, and putting in charge a judge for whose decision the government is in no way responsible. What I don't understand is the claim of the Attorney General that the Canadian Manufacturers Association, the Chamber of Commerce, the Retail Council of Canada, the Federation of Independent Business, and the Insurance Bureau of Canada have all joined hands in support of an early introduction of the Class Proceedings Act. And as I say in the paper, it seems that this is really as eccentric as a lot of turkeys calling for an early Christmas. However, whether defendants like it or not, it is obvious that they're going to be confronted with this statute. And the question on the agenda this afternoon is, how are they to deal with it? And at pages 3 and 4 of the paper, I indicate that the matters I propose to deal with is, firstly, what types of actions are likely to be brought under the new act that were unlikely to be or could not be brought under the old law. So what is the increased exposure the defendants have? Secondly, do the provisions of the new act provide an adequate basis for the courts to protect the interests of the defendant? And thirdly, what are the courts likely to do with the broad discretionary power conferred under these new provisions? I discuss this new figure, the representative plaintiff, at some length, and I don't propose to go over it now, but the closest model, as I see it, to the representative plaintiff in the class action is well known to government lawyers as the public interest plaintiff. And I think they will have many characteristics in common. As you know, in the public sector, particularly under the Charter, but also before the Charter, litigation was greatly expanded by a series of decisions in the Supreme Court of Canada that in effect said it is everybody's interest to require government to act constitutionally. And if there was an issue about the distribution of powers or there was a question of infringing rights, then this is a matter that was justiciable and a vehicle would have to be available to bring these issues before the court. And if the vehicle didn't exist, the court would invent one. And thus we had the birth in the Thorson case, the McNeil case, the Borowski case, of, in effect, a class of private attorneys general who really had no qualification other than that they were interested in taking up the challenge of bringing these matters before the court. And I think one can expect to see in class actions very much the same kind of personality at work. In addition to those more financially minded who are simply banding together in order to run what is essentially commercial litigation on a more efficient basis. But the introduction of this private attorney general into the courts in the public law sphere was created in order that the judiciary could get into the act. That is to say that it enabled the courts to undertake rulings in largely policy areas where the ordinary rules of litigation would have kept the cases out of the court. And because there is a broad range of these cases continually being thrown up, the courts can really pick and choose the kind of issues that interest the courts and therefore regulate their own diet and get into spheres that historically have not been open to judges. And I would expect the same is going to happen with class actions, but the field is broadened from public interest type cases into private interest cases. And when one combines the natural curiosity of the judiciary about many of these areas with the kind of funding arrangements contemplated in the Class Action Act and in the amendment to the Law Society Act, what in effect the Class Action Act, the Class Proceedings Act, does is it creates an empowerment of judges. It really doesn't, as I read it, lock them into a traditional procedure with all the traditional limitations. What the judges will be able to do is to customize, to a substantial extent, rules that, in the opinion of the judge hearing the certification proceeding or in charge of the interlocutory matters, customize a procedure for the litigation of issues that ordinarily would not lend themselves to judicial resolution. Now, if you look on the statute as this empowerment of the judiciary, then the certification procedure is the filter by which the judges determine whether or not they're prepared to customize something for the sake of hearing the issue. And the ability of the judges to do this is essentially achieved by divorcing the legal merits from the traditional economic considerations. The purpose of the Class Proceedings Act, as I read it, is more to deprive the defendant of what the judge may regard as ill-gotten gains, rather than to precisely reward the plaintiffs. Because, as no doubt you looked at this morning, the provisions under which damages are calculated, collected, and distributed show far more regard about getting in the money than about procedures for getting it out on a just basis, including the fact that if there's money left over in the pot after the plaintiffs have got their due, there is provision not to turn that back to the defendant who paid the money in. So the deprivation is more important than the allocation. And of course, by enabling these actions to be brought by a representative plaintiff, and not to have the class members represented by the representative plaintiff as liable for costs, you do substantially cut down the amount of money that may be available to a successful defendant as opposed to the ordinary action. And as you will notice, I think it's section 31 of the Act, there's even a procedure to say, well, even if the defendant is successful, if you enjoyed the case and it raised interesting questions that you think really should have been brought, well, don't give him costs. So that the class action moves along in this sort of procedure which the judge makes up in the certification hearing and then continues to make up as he goes along to the end of the case. And if at the end of the day he feels the whole exercise has been worthwhile, then bygones be bygones and everybody goes home. It is therefore important that the defendant approach the certification hearing with great seriousness of purpose. The first objective, of course, would be to get rid of the action altogether. But that may not be possible, because even if certification is refused, the action is not necessarily dismissed. It can be permitted to continue as an individual action. So the second objective is to use it as a kind of pre-discovery discovery, a pre-trial on the merits, and to get on the record as many concessions and to narrow the issues and to generally focus the debate on ground that the defendant is capable of fighting on as possible. And the statute does offer some scope for doing this when it lays out the 5 criteria for certification. And although my guess is that the judiciary will be favorably disposed towards certification, the defendant can probably get a lot of mileage out of the process itself, even if it is on the face of it in a losing cause. The 5 criteria are set out at pages 7 and 8 of our paper. And I just want to address each of them briefly from the defendant's perspective. The first is that the notice of application has to disclose a cause of action. That is the reverse of the test under Rule 21, where the defendant moves to strike a claim for failure to disclose a cause of action. And while it is very difficult to succeed on such a motion if you're trying to demonstrate the absence of a cause of action, there may be better success when the onus is on the plaintiff to demonstrate that a cause of action exists. Now, for the purpose of that requirement, one assumes that the court will assume, as it does under Rule 21, that all of the facts set out in the statement of claim are true, and the only issue is whether, if true, they support the cause of action pleaded. As we say on page 10, it's clear that the test is not as high as it is in Quebec, where the test has been judicially pronounced to be whether there is a good color of right, i.e. there is some evaluation of the merit of the cause of action. But it is not, at least in my judgment, hopeless for a couple of reasons. First of all, as to the mere existence of a cause of action, the courts, I think, will look on the representative plaintiff in the same way as they look upon the private attorney general, the public interest plaintiff, to determine whether the matters set out in the statement of claim are really justiciable. And one can imagine in certain environmental cases where the genetic damage to unborn generations is pleaded, that you can usefully explore the causal chain that is said to lead to that conclusion and come up with a theory, or at least an argument, that it simply cannot be established. And that's what we did in Operation Dismantle, where the claim was that testing the cruise missile increased the chances of global nuclear war, which posed a threat to the life, liberty, and security of all of the plaintiffs. And the position taken by the plaintiffs was, well, that is the pleading. Now, you have to, as a court, assume that we can prove it. And the only question then is, well, whether that would give rise to a charter violation. But the court was prepared to say that there are limits to how much they are prepared to take on the basis of the plaintiff's pleading. And in that case, they determined that it was really incapable of proof one way or another. The links in the plaintiff's argument on the face of it, were too speculative to require the court to allow a trial to the plaintiffs. So it was struck out. That is an unusual case, but I would expect in the course of some of the class proceedings that will be brought before the court that that kind of argument will be available. The second aspect of the cause of action, it goes to the nature and extent of the class, because it will have to be demonstrated that the cause of action, it could be brought by all members of the class. And it is not sufficient to mount this enormous class action on the basis that some members of the class could support some elements of the cause of action but not others, and therefore put together a kind of composite man or woman as the representative plaintiff. Having said all of that, I concede that succeeding on requirement 1 is probably an uphill battle. The plurality requirement I would see as even more of an uphill battle. It strikes me that the Ontario Act, while stating a plurality or numerosity requirement, it does so for the purpose of eliminating it. When you say that the identifiable class may consist of 2 or more persons, you're not really giving the defendant much to work with. Particularly when you add that the size of the class is unknown, the fact that the members of the class cannot all be identified is not fatal to certification, as is stated in Section 6. The more promising approach to the class, in my judgment, is the definition of the class. And this, of course, is critical from the defendant's perspective, because normally the larger the class, the larger the financial exposure. And if one can avoid too high a multiplier on the individual losses that may be suffered, then you have achieved a substantial victory. But in approaching the certification hearing, it will in many cases be worthwhile to explore whether the class is all it is made out to be and whether things are as simple as the representative plaintiff lays out. And an example for that is the Urea-Formaldehyde litigation in Quebec. And what happened there was that thousands of owners of houses who had installed Urea-Formaldehyde sued the persons from whom they bought it, sued the contractors who installed it, sued the federal government who had endorsed the product, and had in mind a huge class action that would consolidate all of the issues into a giant mega trial. And once, and superficially, class action on behalf of A, B, and C and all others who have purchased and installed Urea-Formaldehyde sounds as though it's a class of persons capable of bringing a class proceeding. But when this was explored, it emerged, of course, that the class really didn't exist at all, because they had purchased from different suppliers of Urea-Formaldehyde. The different suppliers had made different representations. There were different terms on which the Urea-Formaldehyde was purchased. The suppliers said, well, it all depends on how it's installed. And of course, there were enormous numbers of installers who used different techniques, used differing levels of skill in installation. there were a whole range of different issues and conflicts, or at least lack of commonality, that emerged within many of the subgroups who purportedly made up the class. And on that basis, if there really are no common issues, or if the common issues are submerged in differences, then there is a fair argument to get rid of the class action. Now, from the defendant's perspective, all you may succeed in doing is dividing one mega trial into 500 giant trials and really destroy any merit that your client has to offer by burdening him with a litigation mess. But and the urea-formaldehyde litigation did proceed in Quebec as a series of test cases, and ultimately they were rejected at trial. But my purpose is simply to indicate that there are avenues which a defendant will want to explore prior to certification on that second point. The common issues I've already adverted to. The thing to keep in mind, I think, is that if there is any cost benefit to a class proceeding, it lies in the common issues. And the court will have to make a determination as to whether the benefit of jamming these claims together as a class action outweighs the disadvantages. Here, again, I revert to the theme that what the Act represents is an empowerment of judges rather than a procedure in the normal sense, because, as is stated at the bottom of page 12, the definition of common issues under Section 1 means, quote, common but not necessarily identical issues of fact, or common but not necessarily identical issues of law, that arise from common but not necessarily identical facts. Now, who knows what that means? I suppose at the end of the day what it means is whether a judge is prepared to take it on and say that, well, there's enough here. Section 1 says it doesn't have to be identical. I suppose there must then be something that is common but not identical. And it's probably efficient to have the common issues, to the extent they exist, tried under the aegis of a class action. I mean, there has to be some element of commonality in the facts or in the law, but not both. And as I see it, that really is just a recipe to the court to say, look, there it is. You make up your mind as to whether there's enough here to warrant the bringing of the proceeding. The next requirement, the preferable procedure requirement, is more hopeful from a defendant's perspective. We discussed it at page 14 of our paper. Again, it says the proceeding would be preferable, but it doesn't state any standard by which the preference is to be judged. In the United States, there is a superiority requirement, which was considered and deliberately put aside. What you are going to be looking at is the alternative procedures, such as a joinder of the various plaintiffs to an ordinary action, consolidation of a number of different proceedings, third-party proceedings, and so on. Here again, you may win the battle and lose the war. By opting for consolidation or third-party procedures, you may, for the defendant, simply you get your client into a much bigger battle with many more lawyers on the opposing side representing the various interests than in a representative or a class action. And clearly there will be instances where joinder is out of the question. If you're dealing with a great many small plaintiffs who have relatively little at stake and who are geographically spread around, a court will quickly come to the conclusion that it's not fair to impose joinder as a condition of that matter proceeding. I mentioned earlier Operation Dismantle, which proceeded as a kind of giant festival of public plaintiffs. It wasn't formally a class action, and it probably illustrates the limitations of a class action, because the relief sought was essentially an injunction against the testing of the missile and a declaration that infringed charter rights. And really, that could have been brought with one individual, and the remedy would have been the same. And in fact, the only reason for the multiple plaintiffs was for purposes of giant press conferences in which many more spokespersons could be put forward to discuss every phase of the action before it got into the courtroom. But if you look at it in legal terms, a judge may very well say, you're after an injunction or a declaration. We don't need everybody and his aunt and uncle in the class. The matter can proceed as an individual action without prejudicing the plaintiff's claim. The worthiness of the representative plaintiff at page 16 is thought to be perhaps the most fruitful source of a defendant's attack. It consists of a multiple choice test. The first is that the proposed representative plaintiff can fairly and adequately represent the interests of the class. Now, it is sometimes said that the fairly refers to the absence of a conflict of interest, but it seems to me that as that is already dealt with later in Section 5E, it must mean something else. And I would think that what the court has to bear in mind in these cases is that at the time the certification hearing is heard, this great class of would-be people knows nothing about the action at all. They're out there with their respective injuries, trivial or otherwise, happily going their own way, and somebody has taken it on himself or herself to walk into court and claim an injury and claim the right to represent all of these people. And it may simply not be fair to have this particular plaintiff taking on his or her shoulders the pursuit of a claim which may be of considerable importance to a broad class of people. And while there is a good deal of discussion about the court won't look at the merits of the counsel who's going to bring the case forward, and the court won't be looking at how much the plaintiff knows, because really it's the lawyer who runs the case and the expert witnesses who prove it, I would think there has to be some concern on the part of the judge. Is this the proper representative plaintiff to run with this action? And the example that we give in the paper is the Borowski case. Borowski, as you know, challenged the Section 251 of the Criminal Code, the abortion provisions. Borowski was a former minister in Manitoba who was in no danger of becoming pregnant, who had no medical qualifications, was never going to be called on either to perform or not to perform, make a decision not to perform an abortion. His motive was essentially religious and emotional. And one might ask, why is it that when you have a section of the criminal code that involves every woman in Canada, every doctor in Canada, hospitals, all manner of people in a direct way, why is it should this zealot come into court and say, I represent them all, and if I crater in my lawsuit, they're all bound? And there must be under the word fairly, or if not somewhere in this section, a value judgment by the judge hearing the certification order that yes, you know, this is an important issue and this is the person to bring it. It may be in the word adequately, but adequately may also refer to the resources that are going to be put behind it. If there's a major environmental battle, there could be quite extraordinary disbursements for experts and the kind of effort necessary to adequately put the issues before the court. And while there's this Law Society fund for class actions, there may be a limit as to how much the Law Society is prepared to invest. The judge will want to look at the plan. The second requirement of the worthiness of the representative plaintiff is that there is a good plan of action. And quite often, at least in the case of public interest to plaintiffs, there's really no plan of action at all beyond the initial press conference. There was a class action recently commenced by Maureen McTeer against the Commission on New Reproductive Technologies, which was launched with tremendous fanfare and which has never gone anywhere because the purpose, of course, was simply the publicity attendant upon initiating this major piece of litigation. It will be important in many cases to say, look, this is not something the court should get involved in. This isn't a serious piece of litigation. It is simply a political or economic or social crusade carried on by other means. The third element is this absence of a conflict, and that is fairly self-explanatory. Now, I notice in the presentation this morning, the Americans have developed in their usual way categories of cases: the ignorant plaintiff, the fanatic plaintiff, the busybody plaintiff, and no doubt we will build up classes of jurisprudence around all the various defects in certification applications. But I would think at the end of the day it's going to be a smell test that the judge is essentially satisfied that, look, here is something we ought to listen to, and this is as good as anybody to bring it forward. And that was the test ultimately that the Supreme Court of Canada came down in Borowski. If there's a genuine interest, and if the issue is one that we ought to look at, let her rip. And that may well be what it comes down to, the test in Section 5. The certification order, which we deal with starting at page 17, is extremely important. Remember that as of this stage, the certification hearing, this great body of the members of the class know nothing about what's going on unless there's been a preliminary press conference. Somebody's come before the court, made all these arguments in the absence of the people who will ultimately be bound. The certification order, which should but will not necessarily be communicated to all members of the class, has to describe the common issues and the prayer for relief, amongst other things. And as a defendant's counsel, you'll want to be very clear about how those are worded, because that is going to be the basis of a plea of res judicata to any future litigation. When you say all members of the class are bound by the outcome of the litigation, the question is, bound by what? Well, they're bound by what's in the certification order. Why is that? That's all they had notice of. And if they decided not to opt out, or they decided not to get involved, it's because they took at its face value what was set out in the order as to the common issues and the relief. The second reason why the defendant has to pay careful attention to the order is the opting out provisions. If there's any advantage to defendants in this procedure, it's at least to have a finality to litigation. And if the class action is a leaky ship and people are going overboard, the defendant can find itself confronting the class action and succeeding, only to find that there are all kinds of people who have opted out and who are free to fight another day. Of course, if the class action succeeded, all of these people will climb on board and say, well, while technically those issues weren't decided in an action to which I was a party, one can expect that the same issues will arise in an action that I intend to start, and therefore I should get in on the settlement. So subject to limitations, defenses, it is important that this opting out matter be clarified. In the notice of certification part of the paper, beginning at page 20, various provisions are set out, including the fact that under section 17 the court may dispense with notice to the class that the certification order has been granted. Under the statute, there are provisions for notice to be given to the class by the representative plaintiff at various stages, and the judge has a broad authority to require notice to be given where he thinks it appropriate and necessary. And from the defendant's perspective, it is important that this be watched, because it is only through the communication back and forth between the representative plaintiff and the class that the plaintiff takes on its representative coloring. Otherwise, the action simply becomes a personal vehicle for the plaintiff who pursues it free of the intervention of those who have a substantial stake in the outcome. Now, much of the balance of the paper deals with procedural matters that I think are of somewhat marginal importance to the discussion at this stage. I would, however, like to say a word in conclusion on the matter of damages, which we discuss in our paper starting at page 25. I said at the outset that this is one of the areas where it is clear that the government's objective was as much in punishing the defendant, or more in punishing the defendant, than in rewarding the plaintiff. And the way that emerges is that the techniques for assessing damages make use of a number of measures that may give some approximation of the benefit to the defendant of the allegedly defective conduct, but may not say much about the loss to the plaintiff. The provisions, I think, were inserted clearly to avoid a kind of scorched earth defense by a defendant, requiring each member of the class to come in for discovery, each member of the class to produce a receipt to show damage, each member of the class to jump through all the hoops of an ordinary piece of litigation. And therefore, for example, under Section 23, the judge may allow evidence of polling or sampling or other techniques to demonstrate loss. So that in the example given in the paper, if there's a Ontario Hydro meltdown and there's a massive interruption in service, it's not necessary for all members of the class who suffered interruption to establish particular losses. The court can introduce sampling and other statistical information. And that has a logic to it. But from the defendant's perspective, it may be extremely difficult to counter that kind of evidence without replicating the sample and the poll, and then getting into a contest as to which poll and which sample better represents reality. So that the judge ought to be cautioned, it seems to me, in order to hold a fair balance between the plaintiff and the defendants, that this kind of evidence, which seems reasonable but which imposes a substantial burden on the defendant, should be approached with a certain measure of caution. Finally, at page 28, we address the likelihood that the courts are going to resort to these broad discretionary powers with enthusiasm. And our guess is that the courts will do so because in many areas of the law there seems to be a judicial awakening to the fact that regulatory procedures have in many cases broken down. Either because government isn't putting enough money into the regulatory procedure, or because the regulators are getting too close to the regulated, or for a variety of reasons, industry is not kept in as close check as it ought. I mean, one of the reasons behind regulated industries is because of the widespread distribution of small losses, as in the Bell telephone charges. It really is not worth the private sector supervising the utility or other regulated entity. So what is happening here under this act is that the same rationale, not having reached fulfillment in the regulated system, is now being handed into the courts. And the courts, of course, lack, in many cases, the kind of expertise in dealing with those issues that the specialized tribunals possess. But if you look at the decisions coming out of the Supreme Court of Canada, and particularly the wholesale travel case that's referred to at the bottom of page 29, there is a high level of anxiety in the courts that the regulatory system is underfunded, is understaffed, under-resourced, and is not doing its job. And therefore, for example, in wholesale travel, the courts established a kind of non-charter area of criminal law known as the regulatory offenses, which don't have to pass any of the usual tests for putting people in jail, but which, because they are regulatory and are thought to avoid the Chernobyls and Bhopals of the future, are upheld. And this same anxiety in the judiciary in relation to industries which are capable of doing widespread damage is going to, in our judgment, feed the demand for class actions and generate judicial enthusiasm to see that they are given acceptance. So that's an overview from the defendant's perspective. Thank you.
Present you with this watch. And, we were able to keep an extra few minutes here for questions for Mr. Binnie arising out of his paper. In a minute, we're going to move to Leah Price's presentation on just the government perspective on class proceedings. But if Mr. Binnie has a few extra minutes, Mr. Binnie suggesting that maybe Leah should speak first, and we'll take all the defendant questions at the end of that. Seems to suit everybody fine. Okay, Leah Price is next. And just by way of introduction, as I was mentioning, Leah is a former colleague of mine at the Ministry of the Attorney General. She's presently the acting director for the Crown Law Office Civil. She graduated from the University of Toronto with her BA in '71, an LLB in '74. She went to the University of London for an LLM in 1977 and was called to the Bar of Ontario in 1976. She's certified as a specialist in civil litigation, and from 1981 to 1986 was a partner in the firm of Campbell, Godfrey and Ludis. She was, prior to that, a sole practitioner and has also had a stint as counsel in the Constitutional Law Division of the Ministry of the Attorney General. She's moved rapidly up the ladder at the ministry and jumped at the opportunity to get involved in this program because I think she has some very interesting views on the potential impact of this procedure on government, which no doubt will be on the receiving end of a few of these actions. So, Leah Price.
Thank you, Michael. The way Michael started, that government will no doubt be on the receiving end of a few of these has to something to do with why I'm here, because actually when I received Mr. Binnie's paper, I had a look at it, and I said, I must say I read with interest his paper and the theory that he advanced there and that he advanced to you today, that the Class Proceedings Act is designed, at least in part, to advance the regulatory interests of the province of Ontario by holding accountable careless, polluting, fraudulent defendants. And he points out, or at least he suggests, that the cost to the government of such quasi-regulatory action would be very little. He does concede, perhaps a little reluctantly, that the Crown, after all, has bound itself, so the Crown is not making it adding to anyone else's burden, a burden that it isn't willing to take itself. I'd like to suggest that if the Class Proceedings Act is regulatory in nature, we may find that the greatest burden of this regulation falls indeed on the government. That, I would suggest, is clear from the advisory committee report that Michael chaired, in which they said, for example, that the presence of effective remedies of any sort must contribute to a sharper sense of obligation to the public by those whose actions affect large numbers of people. This is the case whether the obligation is owed by an aircraft manufacturer, a pharmaceutical company, a financial institution, or even a government. An effective class action procedure has a potential to contribute to improved compliance with such obligations. I would suggest that it wasn't far from the minds of certainly the advisory committee that one of the improved compliances that we're thinking of is improved compliance by the government with its own regulatory obligations, or at least what some people might think are its duties to create regulation or its inability to regulate, to the extent that the representative plaintiff might think the government ought to have regulated. Experience has shown that a large percentage of mass claims or test cases are indeed brought against government. Examples of areas that are likely to be active, and indeed have been active in the past, include charter remedies, and I think particularly in connection with the Class Proceedings Act, of remedies that may be available under Section 24 of the Charter, which, as most of you know, is a specific section that does provide for remedy. Since the Charter is, of course, binding on government and not on the private sector, this fertile field of litigation would be one that would be used and essentially solely against the government. Aboriginal title claims would be another area of interest and activity, and again, that would be essentially claims against the government, though obviously any such actions could affect, depending on the size of title claims, a lot of other people besides the government, the public at large. Other areas that have been in the past active and would no doubt be more active in the future would include mass disasters. One of the things that people often forget in a mass disaster situation is that there's often times that the industry in question is regulated, or the representative plaintiff might say should have been regulated by a particular government entity. So what we found in the past, and what we undoubtedly will find in the future, is that in a class action, government may be joined on the basis of an allegation of inadequate government regulation or response, or else an untimely government regulation or response. Examples that we've seen already include the Air India disaster and the collapse of Astro Trust and Remor, all of which spawned actions which did involve the government. Another area that has been in the past litigated in a different fashion than it may be litigated in the future is claims based on statutory interpretation. One of the things that we see a lot of, and I particularly have a great deal of involvement in, is actions or applications for declaratory relief, where the allegation is made that a particular statute should be interpreted in a fashion different than the government thinks it should be interpreted. Now, in most of those cases, the action as currently constituted, or the application, would seek pure declaratory relief. The effect, of course, if successful, would be the same as if somebody actually got damage claim. But the class proceedings procedure that is set out in the Class Proceedings Act would no doubt encourage this sort of process, because of course there are advantages, as Ian has pointed out, to the Class Proceedings Act procedure which do not exist currently to either plaintiffs who litigate by way of application for declaration, or who aggregate their claims and name 250 people or however many people are the targets of the legislation. One of the most obvious examples of that is, of course, that the members of the class are not themselves liable. So if they're wholly wrong and the action is unsuccessful in the government's interpretation, for example, of its legislation, is upheld, the liability for costs of the individuals doesn't exist, and one might suspect that the representative plaintiff might not have an awful lot of assets to answer to a costs award. As I indicated, many of the kinds of areas that the government's likely to be subjected to or defendant in under the Class Proceedings Act already proceed. But as I mentioned a minute ago, there are advantages. Mr. Binnie called it empowerment. I call it encouragement of litigation of particular kinds. The advantages, besides the issue of costs that are mentioned, include, of course, the possibility of there being no costs award at the end of the day, if in fact the claim is a novel claim or a test case of sorts. Also, there is the access to the Class Proceedings Fund, which of course doesn't exist under any other kind of procedure. So again, a representative plaintiff or a public interest plaintiff, or someone who wishes to take proceedings against the government, has less to lose at the outset. As well, an issue that in my view will be very significant is the ability of lawyers to enter into contingency fee arrangements, which would not exist in the kinds of litigation that we're now seeing against government. That too would be likely to encourage people who might not otherwise find it economically sound to litigate against the government to launch what may turn into very, very massive cases because they needn't have the same arrangements with their lawyers, and the lawyers might take on cases on a lower threshold of likelihood of success. The Crown's concerns in that area may be, to some extent, similar to the concerns of other defendants. I suspect that the difference between the Crown as a defendant and other defendants is to do with size and sheer numbers. And as well, the Crown has a particular concern in litigating, in that it is, of course, the regulator. So what if what is being challenged is the very issue, the very regulation that the Crown and the government is proceeding to apply? If litigation is commenced on a representative basis, the Crown is in the difficult position of determining whether or not they apply the legislation as it stands, or whether to take any further steps or accelerate policy reconsideration, given that a litigation which may have major scope and, as Mr. Binnie said, would likely receive a great deal of publicity, is ongoing. There is a real danger, in my view, that the publicity issue, the Globe and Mail factor, if you will be even more important to the government than it will be to ordinary defendants. Now, in my paper that I provided to you, I did spend some time on the area of litigation as against the Crown. That is, of course, special to the Crown, and these are procedural issues. I spend some time in my paper going through some of them. I'd just like to highlight, with that introduction, some of the particular issues that we've been finding oftentimes are forgotten. I should point out, firstly, there's a typographical error. The reference on page 3 to the binding on Her Majesty the Queen is a reference to section 36 and not 30. That's an error in the text I'd like to correct. It's important to note, however, that while the Class Proceedings Act is binding against the Crown, it does not override the Proceedings Against the Crown Act. Indeed, the Proceedings Against the Crown Act overrides the Class Proceedings Act. So it'll be difficult, particularly at the early stages of this new procedure, to coordinate the requirements of a class proceeding with the procedural difficulties inherent in the Crown Proceedings Act. So if I can spend a few minutes of my remaining time to deal with a couple of these anomalies, essentially what I want to do with you is to draw your attention to these issues. The information is there. It can be found. You can even pick up the phone and call me and ask me, though, me or someone else perhaps, and the information is available. However, we find that it's a fairly common circumstance that the requirements are not met, and it causes more difficulty. In the procedurally complex cases that are going to be undertaken under the Class Proceedings Act, it'll be even more difficult to deal with the problems that will arise if counsel isn't very careful to ensure compliance with the Proceedings Against the Crown Act. Now, at page 3, I speak of the first requirement, and this is the one that is particularly important because it's at the very outset. And Section 7 of the Proceedings Against the Crown Act does require that notice of the claim be delivered. The case law, little as there is on this particular point, suggests that if notice of the claim is not provided in accordance with Section 7 of the Proceedings Against the Crown Act, the action once commenced is a nullity. So it doesn't do a whole lot of good to go a long way down the road. If you haven't provided the notice to the Crown, you face the possibility of having your action declared a nullity and having to start all over again. The position that we take is that the notice of claim should be in writing. It's safer, again, complying with these, fewer problems, and that notice should be provided to the Crown Law Office Civil Law, which is at 720 Bay Street in Toronto at the 8th floor. That's my office. The requirement of a notice is not just a technical requirement. I often hear this complaint, but it is because the Crown is a very large and very varied and very diffuse entity, a very important requirement in order for the matter to proceed. Matters are indeed settled by the Crown from time to time, and even a proposed class proceeding could be settled if it's sufficiently clear from the materials that are provided from the note in the notice of claim that it ought to be settled. But it's very difficult to do so if there's no notice. We don't even know who it is that is alleged to have done wrong and to whom. We also carry insurance. This is something that many people aren't aware of. And since the Crown carries insurance for particular kinds of losses, the Crown, in particular in a class proceeding, must have some idea of what the potential size of the claim is in order to determine whether or not it mightn't be over the insurance limits, which, while very high, are not unlimited. We also have to determine in the cases whether in fact the claim would fall within our insurance limits, because like other defendants, we must provide notice or we run the risk of not having insurance for the claim. So apart from the requirement to serve a notice in order to make sure you have an action, I'd also suggest that the requirement to serve a notice serves some very important practical purposes, some of which include the possibility of settlement. The provisions of the Act, of course, provide that after the notice of claim is served, a 60-day waiting period ensues. Any time after the passage of that 60 days, an action can be commenced. I point out at the bottom of the page 4 that the Class Proceedings Act does not explicitly provide for discovery of documents. It does provide in subsection 15.1 of the Bill 28 that the rights of discovery under the rules of court are to apply. However, insofar as discovery of documents and oral discovery are concerned, the Proceedings Against the Crown Act again provides for special advantages to the Crown. And here again, since this Act overrides the Class Proceedings Act, that's the provision that you have to look to. So at page 5, I list the Section 8C, which provides that only a list of documents need be provided, and in addition provides a specific right to refuse to produce a document. This would be a document that would otherwise be relevant, or answer any questions on the grounds that the answer would be injurious to the public interest. Now, there has been extensive litigation culminating with the Carey case, which is shown at note 8 on that page, discussing this question of public interest privilege or cabinet privilege. And without getting into too much detail about this difficult area of the law, it is open to the Crown to refuse to produce relevant documents on the basis of cabinet or public interest privilege because of the operations of government. So if you're looking for documents from the Crown, you might be well advised to look at that case and to determine if in a class proceeding or in any other proceeding you can have the extensive discovery that would be available against other defendants. Similarly, Section 8B provides that the person who attends to be examined on behalf of the Crown when the Crown is a defendant shall be an official designated by the Deputy Attorney General. This creates a discretion in the choice of the person produced for discovery that doesn't exist in favor of any other defendant. I do suggest over the page, on page 6, a way to get around this, if what you want to do is examine a particular official who you think is responsible for the loss the plaintiff, the class has suffered, you can name those individuals as co-defendants, and then of course the provisions of that section would not apply. I also point out on page 6 as an aside that the Freedom of Information and Protection of Privacy Act is a useful tool that lawyers sometimes take advantage of, but perhaps not as often as they might, which might be particularly useful in class proceedings where a representative plaintiff who undoubtedly will be doing initial research to ascertain the nature of the claim they might be able to present against the Crown, or possibly the nature of the identity of the class that they intend to represent, could make a request to government for information under the Freedom of Information and Protection of Privacy Act. The utility of that section is limited insofar as the information that may be requested is considered personal information within the meaning of that act. But to the extent that that information is not personal information, there are a number of exemptions, but it is a fertile field for information that a class plaintiff or representative plaintiff might be able to take advantage of. This is, of course, a source of information as against government that would not be available as against other defendants. These provisions that I've pointed out are just a few of the provisions of the Proceedings Against the Crown Act that are of relevance. They are the ones that are perhaps the most important. What I do wish to point out to you, though, is that there are other provisions in the Act that provide advantages to the Crown. One of the ones that you should be aware of, and may be particularly important in class proceedings, is that trial is to be without a jury, so that we won't get in Crown proceedings the kinds of awards that perhaps you've heard mythically in America, where the jury awards $150 billion or what have you against the hapless defendant, unless of course the judge can be convinced that that is a true measure of the damages suffered by the class. Another area that you should be looking at is that certain remedies are not available as against the Crown, and most importantly, that would include injunction properly so-called or specific performance. That's more technical than real, because the reality is that anyone who actually wants to get an injunction can usually get around it by naming a particular official rather than the Crown, or alternatively by seeking a declaratory order that has as its effect the stopping of conduct that is complained of. I also, in my paper, starting on page 7, refer to a problem that may exist as a result of the effect of the Public Authorities Protection Act. Currently, the Public Authorities Protection Act, and this is another unusual feature of the Crown, and it wouldn't, of course, just apply to the Crown. It would apply to municipal corporations and other public authorities, but it is very much applicable to the province and provincial entities, does provide for a 6-month limitation period. Now, what the Proceedings Against the Crown Act does, and this is fairly complicated to put down on paper, but not that hard to understand orally. The Proceedings Against the Crown Act, of course, provides for an extension of time, so that if you're faced with an action against a provincial official who is carrying out a public duty that you say has been done negligently, and you have a whole group of class plaintiffs or class members who say that they've been harmed by this action of the government, you should commence the class proceeding before the 6 months are up. Now, in order to do that, you have to serve the notice of claim upon the Crown prior to the expiration of that 6-month time period. And then, of course, the Proceedings Against the Crown Act, and this is explained in some detail in pages 7 and 8 of my paper, but the Proceedings Against the Crown Act then says, in effect, once you've served your notice, you don't have to worry about the limitation period until the 60 days notice period is up. At that point, you have exactly 7 days to institute your proceeding. And that's, if you'll see at the at page 8 and 9, the steps are set out. The Class Proceedings Act itself does stop the time running. So if the class plaintiff, the representative plaintiff, is very careful, serves a notice on behalf of the class within the 6-month limitation period, then commences the class action between 60 and 67 days after that, the time then stops running for the entire class in accordance with the Class Proceedings Act, as is shown on page 8 and 9. However, of course, time will start running again under Section 28 if the action is decertified or otherwise dealt with. So it's very important, in considering the fact that we have a very short time limit, that steps be taken immediately if decertification occurs, to protect the rights of the plaintiffs, to prevent their actions from being time barred. A simple solution would be to try to move your action along well within the 6-month period, thus preserving whatever short period of time exists after the Class Proceedings Act is decertified or otherwise dealt with, so that the individual plaintiffs can proceed and still have time to proceed individually. That's a very complicated way of proceeding, but it's something that I thought would be of sufficient importance, given the real possibility of decertification, that you should all be aware of it. There are other problems that are adverted to, such as security for costs, in my paper, but it's safe to say that until we've had some experience with the Class Proceedings Act and we see just how often it's resorted to and what the particular problems are, we won't be able to say to what extent it's a brand new creature or just a variation of some very old and very lively creatures. Thank you.
Thank you, Leah. We have about 15 minutes for questions, and I thought for fun, if you wanted to tell us before you asked your question whether or not you think you'll be acting for or against the butterball turkey that Mr. Binnie refers to, we might get a glimpse of your practice. We have a question over here. Okay. Did either?
It just seems
Yeah.
to me that the rules need a bit of help and clarification in these extraordinary circumstances, that they're not enough to tell you what to do on your own.
And just for the record on the videotape and the recording, the questions about the application of third-party procedures, cross-claims, counterclaims, and so on, by a defendant against the class. And where does this aspect of civil procedure fit into class proceedings when there really isn't much mention in Bill 28, the Class Proceedings Act, about this, other than a statement, I think it's in Section 35, that says the rules of civil procedure should apply. So I'll let our panelists take a stab at it. Seems to be on.
Well, I was wondering about starting a counterclaim against the class earlier, but it's kind of hard to think of a situation where a class that regards itself as wronged by some act of the defendant is sufficiently implicated in the wrong to justify a counterclaim against the whole class. I think it is important that the rules of court provide and that counterclaims are open to the defendant, because one of the things we suggest in the paper is that if you have a counterclaim against some but not all members of the class or an individual, you start to shift the focus away from the class aspect, and you introduce more color that the important litigation is really the individual litigation, and that burdening it with the class procedure is really not an effective way of dealing with the resolution of the claims. I think the short answer to your question, which you mentioned yourself, is that yes, the rules of court provide or apply. Yes, it would be open using those rules to create class actions upon class actions if you could ever find any judge willing to certify it. But it's a little difficult to conceive of practical circumstances in which quite that much complexity would recommend itself to a judge to allow to proceed.
Well, what about the case of a third party then? The rules of court provide for a third party being able to defend the main action. Would that go so far as to let a third party go through a second certification process if you wanted to?
You might want to repeat
Can
it.
I just address an interesting comment arising out of your question on third parties? I can certainly see the possibility. One of the things that we find too is that the Crown is often named as a third party. And I hate to use specific examples because they might be taken up, but let's just say by way of example that a group of tenants bring a class action against one landlord for, let's say, illegal rent. Well, then the landlord turns around and say, oh no, it's all your fault, government, because of the retroactive rent legislation. And they band together and attempt to certify themselves as a class group to third party, the government. So you can see that that Ian's point is well taken. At what point is the court going to say, oh my God, I can't deal with all of this? So while in theory, you can see that example, is one that wouldn't be beyond the realm of possibility. You can see that once you would want to build one action on top of the other, the complexity would be such the court might not be able to deal with it. Might say, oh no, you take your action separately or sequentially.
I would have thought that, yes, it would be open clearly to have the defendant could launch a third-party proceeding. The third party would be entitled to defend the main action, but the main action at that stage is a class action. So I don't think the third party would have to go through, or there would have to be another certification hearing, but there may well be a decertification hearing under Section 10.
Question up here? You don't want to call your clients turkeys, do you? Right. This question's about who can be in the class for a suit instituted in Ontario, and is it possible to have class members who are outside the province? And maybe I'll reserve my comments until we hear from the other two panelists.
Well, I don't know whether it was considered or not, but I would assume that that doesn't present a problem in Ontario, except insofar as this complexity is a factor in the judge certifying the class and defining the issues and so on. But obviously, the foreign jurisdiction could then look at what went on in Ontario and determine whether, from its point of view, the procedure was such that the Texas member of the class should be bound by what went on in Ontario rather than having the ability of initiating an action there. So I don't think Ontario can bind any other jurisdiction, but Ontario judge would be bound to follow Ontario law and leave foreign defendants to their own remedies, or foreign members of the class to their own remedies.
It's also an interesting question that occurred to me yesterday when I was looking at this material, and I don't know if Michael's ready to make his comments, but what I wondered about was, what about the argument of forum non conveniens? Is that going to be available to people like, let's say, the Crown or other defendants, if it appears after some investigation that a good percentage, if not the majority of the members of the class are indeed located outside of Ontario? Should we then proceed with the Ontario class proceedings process, or should you say, well, really this should be a Texas action or an Alberta action or what have you? Sorry, Michael, to add a comment, but it arises out of this question.
No, it's helpful because this is an issue that didn't come up during our discussions in the task force about whether or not people outside the province could be in the class, although there's been quite a bit of discussion about it since, and it seems it's one of the questions that comes up when we have the conferences, and there's a difference of opinion on it. One school of thought seems to be that it shouldn't make any difference if the person who resides outside of the province is capable of bringing an action here because they were a victim of a telemarketing fraud or something like that. It doesn't really make any difference whether they're a member of a class or they're the representative plaintiff. If they have the right to bring an action in Ontario, then they should be in the class. The other side of the question seems to be the one that if they're not in Ontario and we can't really exercise any control over that person, then how can we possibly have a lawsuit instituted on their behalf? So as a third approach to it is that maybe people who live outside of the province constitute some kind of subclass of the class that is in the province. And I'd be interested to know, Bev's up at the back of the room, but this might be a question that we should come back to and see how it's been handled in the American jurisdictions where they have individual state class action procedures and a federal class action procedure, and see if they had some maybe some guidance for us on it. Ron?
Yes, we'll be representing turkeys and meat eaters. The opting out. He was mentioning one of the big advantages of Ranger Cat having the whole thing dealt with at the same time. But Ian had mentioned in his presentation that some people could stand by, I think it was Ian, some people could stand by, opt out, and if there's a good result and finally the judge rules that yes, causality is established and you win, well then they come in and say, gee whiz, if we're not out of time, if we haven't missed the limitation period, we win. And if the class loses, they're not bound by res judicata. Now the only way the defendant can sort of, can be fair, if I can use that word, is if at a certain point the judge can rule that all potential plaintiffs have to be bound by the decision. Because otherwise than that, I mean, it's just a waste of time. The smaller cases that are not worth a lot of money, they'll all join up in a class action and cost the defendant a lot of money. And yet all these big claims, they'll just wait and then they'll each come one after the other after the defendant. I'm wondering if there's any, if you give me your thoughts on that.
Well, perhaps Leah, but just my point, which I think was in your question, is that not that the person who opts out as a matter of law has advantage of the judgment, but in practice, it appears to me that it's going to be a hard-minded defendant to relitigate the whole thing if the action's already been determined against him. I guess on the merits, I think there has to be some kind of opting out provision, and it has to be broad enough to take into account, to allow a judge to take into account whatever ground is raised. But clearly, if opting out is permitted on too broad a basis, then it has this catch-22 effect, which should be avoided. And it seems to me that one of the defects of the legislation is that it does permit a judge who is so minded, and one hopes they will try to avoid it, but to create a vehicle where the defendant loses both ways.
I don't know if I'd agree that there might be a problem with that, but I have to say that realistically, I had mentioned earlier in my comments that oftentimes the Crown finds itself in effect in that situation because someone will bring an application for a declaration or there'll be a test case. And as a matter of practice, the government, if the court holds, for example, that the legislation is unconstitutional, the government's not going to apply that legislation against other people, even though there's only one particular applicant or one particular plaintiff. I might say, too, that while this could be a problem, I'm wondering if this is going to be real, because if the key issues are issues of causation, they will be so mixed up with issues of law that a court may well use stare decisis to prevent someone from coming along and trying to relitigate the issues. I suspect that that'll be true of the key legal issues that'll arise. So it may be that there will be a problem to some extent, but I rather suspect that the courts may be pretty open to arguments to say that the issues have been determined by the use of stare decisis.
So then there's not really any opting out.
Well, there is, if the issues are purely issues of fact, I would suggest. If there's a real different factual nexus between the opted out proposed plaintiff and the class, then I think I would suggest that it's both fair and appropriate that there be opting out, and then it would be both fair and appropriate that they not be bound by the result.
If there are these differences, there wouldn't be certification of the class in the first place.
Well, there are subclasses. I mean, Michael may be better able to
Yes.
There would be, where there would otherwise be subclasses. I suspect that certification could arise, particularly with subclasses, even where there are, since there would be issues in common, but there might be issues, significant issues that are not in common.
Yeah, the other point I just wanted to pick up before we take some of these other questions is the one about the plaintiff who opts out, sits on the fence, watches the action, and likes the result in the class action, and then tries to opt back in to get the benefit of it. There isn't any specific guidance on that point in the legislation, but I think you'd be hard-pressed to get back in once you'd specifically opted out. So, but it's a interesting point. In the middle? Yeah, the point just... Yeah. The observation being made is that the effect of opting out on the recommencement of a limitation period, the limitation periods are suspended once the class proceeding is commenced, but if this person chose to opt out under Section 28, the limitation period would start to run against them.
Yeah, but all you have to do then is to commence your action and let it sit, and let the class proceeding forge on ahead. And if they're successful, then you come along and say, well, I'd like mine too.
I don't know if defendants are completely powerless to deal with that situation. While it's, as I mentioned in my paper, that issue of the opted out plaintiff having to commence suit is going to be particularly acute under the current Public Authorities Protection Act because there would be so little time. I rather suspect that if there were protracted class litigation and a plaintiff were sitting in the weeds having commenced an action against the Crown may seek to either have that action dealt with or somehow, I don't know, Michael, maybe you could even consolidate into a class action or somehow make sure that the plaintiff can't just sit in the weeds and then come leaping out afterwards. I could say, too, that there is limitation reform coming at some point, but when that'll come, I'm not sure. That may obviate the 6-month problem. If it comes, it's now proposed that there be, generally speaking, a uniform 2-year limitation period.
Yeah, so the special protection for the government would be eliminated by the limitation reform as it's proposed right now.
At the moment, that refers only to the 6-month limitation period, but not the provisions of the Proceedings Against the Crown Act. Those are expected to continue as to notice and so on.
Lloyd Brennan and then Gary Watson.
Just as I'm trying to get a practical handle on what we've just been talking about, so this is for any member of the panel. It seems to me that in the kind of class action that's suggested by the heart valve cases, you may have a very large class who have some damages, probably very difficult to determine because they're alive and the heart is still working. But there is a subclass or a group of people who have died or suffered very dreadful consequences of that, and their measure of damages is substantially greater. Is it not obvious that that person is going to opt out and sit in the weeds and wait for the liability issue to be determined and say, now I'm coming in for this, not that action, now I'm coming in for it. And I want my $1.5 million, or whatever it may be. Isn't that the problem though of this, or does the class legislation, Class Proceedings Act, permit sufficient individuality with respect to damages that isn't going to be of any advantage?
My understanding of Lloyd's question is about the heart valve litigation in the States, that some members of the class have not actually suffered the malfunction of the valve, as I understand it. So their damages would be different than that group that has suffered the malfunction. In some cases, I think there's a fatality. In other cases, they're able to catch it before the end. But you're right that these people, as described as a part of the class, would be bound by the result, and they may well think that they're better off opting out to wait to see what happens in their own individual circumstances, because they would be able to maximize their recovery. Although I don't know if the plaintiff actually thinks of it that way. And I'd be interested to know, Bev, if you've got any experience on the heart valve case about whether or not the class hived itself into creating a little subclass that dealt with people who had not actually suffered a malfunction. If you can, why don't you come down and join us?
can't be bound by,
You're not
you
bound.
can't bound by stare decisis because it's a different case. The plaintiff who opted out would come in with fresh evidence, and there's no issue with estoppel because it's different parties.
But if the evidence was that this is the same allegedly defective product that wasn't defective in everybody else's case, there was a class-wide judgment that the product simply was not defective, i.e. vindictive.
They're just finding there's no defect on the evidence that was presented in the class action.
Well, unless you can find some specific factual circumstances, as Ms. Prime pointed out, that apply only to the individual plaintiff, it's still be unlikely. The plaintiff's individual case is already lost on the liability.
From the
If I could
government's
just suggest,
perspective, just if I can pick up on that, and it may be because I'm looking at it from the government's perspective, so often it's so important to make a decision of law in order to find liability. So you might talk about, for example, legal issues on whether there's a duty in a particular circumstance, and whether causation is proved as a matter of law or whether it's remoteness. And it seems apparent to me that stare decisis would happen there. The problem of issue estoppel is a real problem and would be more difficult. But if the factual nexus is the same, I suspect, again, that defendants, certainly I would, on behalf of the Crown, attempt to get rid of any later plaintiff if I won the first one alone, based on the legal and common factual issues, if you will.
Well, you see, I think the answer to all of that is that under the statute there is a right to opt out. In Section 9, under Section 8, the judge is required to specify the manner in which class members may opt out and the date in which they have to do so. And if what you're saying is, well, as a practical matter, if they opt out or if they don't opt out, they're still going to be bound by the result, then the argument is that the statute is given an illusory benefit. And I think that a court would be confronted with the argument, look, that's a different case, that's different evidence. The reason I opted out is I thought they were going to do a lousy job, and they did a lousy job. I'm here with quite different evidence to establish on these facts that there was a defect. The statute gives me the right to do it. I exercise my statutory right. Now, don't you, Mr. Judge, turn this thing into an illusion by saying, well, you opted out, but you're bound. No, just different parties. It's not a question of being adequately represented because you'd opted out of the class. You weren't represented at all. Yeah.
Just so the videotapes that people buy later will make some sense, because they've probably just been seeing a picture of the panelists for the last few minutes. The question that was directed to me by Lloyd Brennan was about the opting out and the heart valve situations and the different treatment that might be applied to members of a class who have varying levels of damages. Heart valve that is malfunction as opposed to one that hasn't. And I threw a question up to Bev, maybe unfairly, in the back row, Bev Moore, that I wondered what the experience was in the States. And Bev made the comment that that the heart valve litigation in Ohio, I think, is where it's actually commenced, is a multi-party litigation. And in fact, the experience there is that some of them were opting out of that litigation, and that it's not uncommon in things like the mem transplant cases or other situations of mass loss where some of the losses are significantly higher than others, those are precisely the situations where you see the opting out for pressure from attorneys or because they want some specialized treatment. And my guess is that these are some of the things we're going to see, we're going to have to work out with our own rules in Ontario as we go along. Just from the advisory committee's perspective, I can tell you that we contemplated the possibility that a member of the class would opt out of the action and would be able to pursue his or her own claim without regard to the outcome of the class proceedings, so that while it may make their job more difficult on the finding of liability, it would not shut them out absolutely, that they would be able to pursue their individual claim regardless of the outcome of the class action. I have a question from Gary Watson coming up, but I just wanted to say it's 3:15. Mr. Justice Montgomery is here now to give his paper on a judicial perspective on class proceedings, but why don't we take one more question and then we'll try to move on, or a couple more questions maybe. Gary?
On that last point, I think that from a defendant's perspective, I would certainly argue that a plaintiff who was opting out should do so on the basis of an order from the court that the judgment will have res judicata effect against the plaintiff opting out in any event, and maybe even that through opting out they may not share in the proceeds. Otherwise, the situation gets extremely complicated, and one of the other things that's very interesting to see how it operates is what will the attitude be when a case is brought where the claims are individually viable. In other words, you have claims for whether it's a heart valve case or any substantial case. Michael gets up and starts a class action, and everyone else comes on and says, hell, we don't want Cochrane running our class action.
Who could blame them?
Run our own claim. And the difficulty with doing that is that if you don't have one class action, everybody can let the other plaintiff go forward, unless you're like Mr. Justice Montgomery and says, well, hell, we're going to consolidate all these actions to take a test case, and it's going to bind everybody. Otherwise, everybody's ahead to let somebody else go first. Because if they lose, you get a second kick at the can, and if they win, everyone jumps in and pleads issue estoppel, and then moves to have their damages assessed. So I think that there are two questions. There is one, what will be the terms upon which a defendant should attempt to extract from opting out, and secondly, how will the court deal with the issue of the individually viable claim? And I think that that's a very serious question with regard to the legislation, which the legislation, I think if you read the legislation rather literally, it doesn't seem that the legislation contemplates.
That's
In
right.
fact, you can make a public policy argument, particularly in light of the emerging rules with regard to non-mutual issue estoppel, that individually viable claims doesn't matter. We're going to have a class action. And that's where the question I raised this morning about adequacy of representation becomes crucial, and where the court, I think, will have to get involved with the question in some shape, manner, or form with regard to the adequacy of counsel.
Okay. We had another question over here.
Could I change the subject and ask about the question of costs? Under Section 31(2), it seems that the representative party is still personally liable for the costs of the action. But I look at Bill 29, it would seem that there's some protection in Section 59D.
Four. Yeah.
Is that the situation?
Yeah, this question is about cost immunity within the class. Section 31 sub 2 talks about class members other than the representative party are not liable for costs except with respect to the determination of their own individual claims, which goes back to the point that was raised before lunch about people having the right to counsel on their individual claims, and the answer is yes. It's your expense. So there is immunity for class members on legal costs in connection with the common issue determination. Bill 29, the Amendment to the Law Society Act, this creates the Class Proceedings Fund, talks about the defendant not being able to pursue a a plaintiff with an adverse cost award. And the only way that that dovetails with section 31 sub 2 is that that section in Bill 29 only applies to people who have used the fund. And all we wanted to do was to make sure that where somebody had used the fund and was getting the indemnification, that they didn't have the successful defendant chasing them personally, that it was the fund that had the liability to pay the adverse cost award. So that provision was put in to offer some protection.
So in effect, then, the committee, when they're hearing an application for support from the fund, has the power to confer immunity for the defendant's costs on the plaintiff.
That's right. Yeah. Indemnification for an adverse cost award is what it amounts to.
And deprive the defendant of the right to recover from the representative plaintiff.
That's right.
But in that case, the defendant can recover from the fund as to disbursements.
It talks about a defendant who has the right to apply for payment. It doesn't say he may apply for payment from the fund and be refused by the fund. Isn't that true? And he still wouldn't be able to get it from the representative plaintiff.
No, if a representative plaintiff received assistance from the fund and went the distance in the action and was unsuccessful, the defendant can recover his or her costs from the fund. And now there may be, they'd have the entitlement to recover it. We would guess in 99.9% of the cases they would ask for it, but I suppose there may be situations where the costs aren't pursued. But the indemnification's from the fund. And that's a very high value to a representative plaintiff. Question way at the back.
You're speaking to the chronically underfunded Ministry of the Attorney General.
Mr. Howie's just suggested that if the bill goes ahead as drafted, that the Law Foundation won't have the money to put into it. My understanding is that the Law Foundation has already earmarked the $500,000 and has reserved that money. It'll be paid into an account in an amount of $300,000 first at proclamation, and then a year later, another $200,000. That's a very, very interesting administrative problem, which I'll phone into my colleagues, former colleagues at the ministry. Sunny days.
I think I'd better let that one go.
Yeah. If there are no other questions, I think it might be a good time to move on to Mr. Justice Montgomery's presentation, which I know you'll enjoy. He didn't have an obligation to produce a paper, but as I pointed out this morning, he did a paper for us. It's at the back of the materials. And before I formally introduce him, let me thank Leah Price and Mr. Binnie for their defendant's perspective.